This video will tell you about what to do after you've filed your forms and have opened your divorce or legal separation case. Make sure you've watched the other videos in the virtual divorce workshop first. It will be helpful to watch this video when you're ready to file your forms or right after filing them. Please remember that there are many more steps to complete in your divorce. This video will tell you about what to do next, but you're not finished even after completing these steps. So you went to the courthouse and filed your forms with the clerk's office. Now what? The next thing that needs to happen is called service. Your spouse needs to be served with your filed divorce forms and financial disclosures. This step is very important. Your case cannot move forward until your spouse is served and made aware that you have opened a divorce case against them. You'll then need to prove to the court that this was done properly. Not doing it properly will cause you many problems, so make sure you follow all the instructions carefully. The person who serves your spouse must be someone who is not you and who is over the age of 18. It can be a friend or family member, or you can hire a professional process server. It doesn't matter who does it, as long as they are an adult and not a part of this divorce case. Service means hand delivering a copy of the forms to the other party. These are the documents they must be served with: a copy of all your court forms after they've been file stamped by the clerk's office, the blank response forms for the other party, which you should have gotten when you printed your original forms at the beginning, a copy of your Declaration of Disclosure, FL 140. This is one of the forms you pulled aside from your original set of forms. At some point, you will make a photocopy of this form so you can serve your spouse with the copy while keeping the original for yourself. This is an unfiled form because you do not ever turn them in to the clerk's office. All tax returns filed by you in the last 2 years, even if you and your spouse filed together, and copies of all supporting documentation regarding assets and debts, such as titles, property deeds, and bank statements. Even though you do file pay stubs or other proof of income as applicable with the court, do not file tax returns or supporting property documents with the court. These are for the other party only. Remember that anything you file with the court is visible to the public, and you do not want the public to be able to see your tax returns and other financial documents. You can redact any account numbers except for the last 4 digits and social security numbers from these documents. As previously mentioned, you also never file the FL 140, the Declaration of Disclosure, with the court. Once you have gathered together all the paperwork to be served on the other party, you are ready to have them served. If you don't feel it's safe for someone you know to serve them, or you don't want to involve anyone, you can hire a process server to serve your spouse. Process servers are professional servers and can be found online. They charge a fee for their services. This doesn't have to be a confrontational process. It is okay to call your spouse and ask them to meet your friend to be served. Your spouse does not have to agree to be served or sign anything. If your spouse does not want to be served and refuses to take the papers, your friend just needs to leave the papers at their feet and walk away. They are considered to have been served as long as they were made aware of the fact that they were being served. Some things that do not count as proper service include leaving the forms with someone other than your spouse, such as a roommate, or leaving them for your spouse to find later. Your server must have contact with your spouse and inform them of what is happening. The person who serves your spouse must sign a form called the proof of service. This tells the court that they handed your spouse your filed divorce forms and details when and where the exchange happened. When you print out your original forms, this form will be mostly blank. This was one of the forms you pulled aside before filing your forms, so make sure that you do not accidentally file it at the beginning. Instead, you will give this form to your server, and they will complete and sign it after having served your spouse. They will then give the form back to you. You will make one copy of it and then file both the original and the copy at the clerk's office. Errors on this form cause many of the problems we see for people who are trying to finish their cases, so make sure it is filled out extremely carefully. Once your spouse has been served with your financial disclosures, which ideally they get at the same time as your other divorce forms, you can now fill out the remaining form you pulled aside earlier, the FL 141, or the Declaration Regarding Service of the Declaration of Disclosure. On this form, you will state the date your spouse received your financial disclosure forms and sign it. Once it's filled out, you will make a photocopy of this form and then bring both the original and copy to the clerk's office and file them both. Note that there is no fee for filing these documents. There are some situations that may make service more complicated. In these cases, you should reach out to the Self-Help Center if you are unsure how to proceed, or let us know when we are reviewing your forms if you choose to use that service. Some examples include: if your spouse is incarcerated, it is easy to serve them. You will just need to contact the prison or jail. Some facilities have a designated deputy who may serve your forms for you. Other facilities may require you to have your server give your forms to a deputy or jailer. If you need more help understanding this process, please contact the Self-Help Center. If you feel it's going to be impossible to serve your spouse, perhaps because you are not in contact and do not know where they are. If the other party lives in another country, depending on where they live, the rules around service may vary, and it's important to look up the specific requirements for your case. Once your spouse has been served, you must wait 30 days from the date of service. During that time, you are not able to move the case forward. Those 30 days are reserved for your spouse to decide whether or not they want to file a response. Then one of two things will happen. Either your spouse does file a response or they do not. After 30 days have passed, if they still have not filed a response, You may proceed forward in the case without them. If your spouse does respond, then you will both participate in the case together moving forward. In either case, if you're unclear about what your next steps are, it's a good idea to submit a divorce case review request form online to the Self-Help Center. Someone from our office will review your case and call or email you about your next steps. Make sure you complete, file, and serve the financial disclosures you're preparing today before you submit a review request. Don't forget that you have the option to request a hearing to get court orders before your divorce is finalized. If you need a judge to determine things such as who has custody of your children, the visitation schedule, and child or spousal support, you may want to consider scheduling a hearing. Normally, a judge will make orders on all of those things when your divorce is finalized, but remember that could take months or even years. If you need court orders for those issues in the immediate future, you should file a request for order to get a hearing scheduled in the next couple of months. At the hearing, the judge can make orders regarding child support, spousal support, custody, and visitation. Make sure you wait until you have filed your divorce papers and opened your case before filing the request for order forms. If you would like to download those forms or learn more about the process, please see the Self-Help Center website or contact us if you have more questions. You have to keep doing things to finish your case and get your divorce judgment. If you don't, you're still married. The court will not move your case along for you. You must take the next steps. The divorce process has a 6-month waiting period that begins at the time you serve your spouse. That doesn't mean it's automatically finished in 6 months, but that the minimum time to get a final judgment is 6 months. Most people who represent themselves take about a year to get through this process. If you wait too long without moving your case forward, your case will eventually expire. Remember that if you need to get court orders before your divorce is finalized, contact the Self-Help Center for help with a request for order. Sometimes how long it takes is not in your control, so even if you are doing everything on time, please do not schedule a wedding. You could think that you are nearly done and then have your judgment rejected because the judge has a question about it and schedules a court hearing. It usually takes 2 to 4 months each time the court processes new forms, and there are multiple steps to finish. We hope you have gained valuable information about starting a divorce case. Please see the Self-Help Center's virtual divorce workshop page for more information on the process. If you need additional assistance, please contact the Self-Help Center by phone, email, or live chat.